One of the things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, let's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody, and welcome to the show. Today, our topic is when to use a real estate special commissioner. I'm Andy Fowler, and I'm here with Sharyn St. Clair. If you're new to the show, make sure to like our channel. You can find us on YouTube, Facebook, and X. On each of those platforms, you can find us at the handle @InRem Podcast. That's @InRem Podcast. Also, I want you to go to Spotify, Apple, or another major podcast platform. Go ahead and download an audio version of the podcast. Like, subscribe, leave us a review. Helps us out a ton. We appreciate it a ton. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is asking and answering the question, what are bylaws and when are they needed? Bylaws are for corporations. So if you have a corporation that you've formed, you're going to want to have a set of bylaws. It's basically like an operating agreement, but for a corporation. So to form a corporation, just the formation itself, all you need is to file articles of incorporation with the state that you want to form it in. And then those articles of incorporation basically give the state certain bits of information. It generally is going to identify one director and one officer. You generally are going to add more after the formation. But in order to add more, you have to have bylaws that basically define who's who within the organization and how decisions are made and who has the power to make certain decisions. So basically, the bylaws will say, okay, we have directors. Here's the minimum number of directors we have. Here are the maximum. Here's how long they serve. Here's how they're appointed. And it goes through all that. Then it will say, okay, we have officers. Here's who the officers are. Here's what their powers, duties, and responsibilities are. And here's how officers are selected and appointed. Here's when directors are going to meet. Here's when officers are going to meet. And here's who has the power to sign certain documents, to open bank accounts, to do all these different things. The bylaws define all of that. And so for a corporation to effectively operate, it must have a set of bylaws that basically governs its affairs. Unlike an LLC, at least in Arizona, where our LLC statutes state, hey, if you don't have an operating agreement, that's okay, because our statutes will step in and work to fill in those gaps. It's not the same for corporations. If you have a corporation, you need to have a set of bylaws that basically lay out how a corporation is to operate and who's responsible for making decisions regarding the operations of that corporation.
All right. Thank you, Sean, for the legal update. Quick reminder for the listeners. Every Tuesday, 3:00 p.m. Arizona time is the Creative Finance Collective. What is the Creative Finance Collective? Well, that's a live show with basically attorneys in the space of creative finance that attend and appear to discuss creative finance, what they're seeing in the space, what they're seeing in other states, what they're seeing with respect to what's going well and what's not. We talk about it. But what we're really there is to answer questions from you, the audience. So if you have questions about creative finance, what's working, what are the pitfalls that you might face, this is an awesome time to ask those questions. Usually, as you know, You set a consultation with a lawyer. It's going to cost you a few $100s just to get an hour of their time. We're there with multiple lawyers from different states for free just to talk creative finance. So if you have an interest, make sure to join us 3 p.m. Arizona time. You can find it on YouTube, Facebook, or X. It's at the @InRem podcast channel. Go there. And we're on for as long as an hour, but we're really only on there as long as we're getting questions. So make sure to join us and engage. We'd love to see you there. All right. So today we're talking about what it takes and what it means to have a special real estate commissioner, when the courts might require it, what that looks like. If you're involved in real estate, there's a possibility that you may face the need for a special commissioner. And we're here to talk through what those issues look like and what it means. And with us to discuss that is our guest, Sharyn Younger. Sharyn, thanks so much for joining us.
It's my pleasure.
Yeah, we really appreciate you taking the time. So tell our listeners a little bit about yourself, your background, what it is that you do, your business, and how you got into doing what you do.
Okay, thanks for having me. So I actually was a psychotherapist for 20 years. I want to say half of my working life. I was a psychotherapist dealing with all kinds of personal issues for people. And I can say that psychotherapy as a career does have a shelf life. And when I hit that limit, I realized that I needed to do something different. And so real estate has always been something very fascinating to me. And I got a Groupon to go to real estate school, I'm not ashamed to say, to determine if it was something I really wanted to do. I fell in love with the industry and transitioned from 20 years as a therapist to working in real estate. Shortly thereafter, opened my own brokerage. And what I discovered about real estate is that there is a lot of overlap between psychotherapy as a career and real estate, in that most people that come to a real estate transaction do so because they are in the midst of some type of life transition. Now, as a therapist, I worked through life transitions with people all the time. And as a realtor, I also find that I work through life transitions with people who are divorcing, people who are dealing with the death of a loved one and need to deal with their real estate asset, people who are downsizing because they're empty nesters, people who are upsizing because they are growing and building their families. And so that overlap really helped me see how I could continue to be someone who made a difference for people the way I had as a therapist, but in a real estate capacity. And so in that transition, I really did look for opportunities to work with people who were very focused on those types of life transitions.
So at what point, Sharyn, did you make the transition from, and we're going to break down what it means to be a special commissioner, so on and so forth. But at what point in your career did you start to kind of feel an inkling where you might transition some of what you did in the real estate capacity to focusing on being a special commissioner?
Right. Well, as I said, I started to recognize pretty quickly that selling real estate wasn't necessarily about buying and selling homes. It was really about getting people from one chapter to another. And so I started to do some research and figure out how I could do that in a more official capacity, and discovered that, once I had 3 years of real estate experience and licensure under my belt, I could become a special real estate commissioner and more officially become involved in those types of transactions.
So let's get into, or let's lay some groundwork for those that are watching, because this is a real estate focused podcast, and we like to focus on issues that are pertaining to real estate. But there's a lot of people that are listening that are like, "What in the heck are you even talking about? Special real estate commissioner, so on and so forth. I don't even know what this is." So some might be approaching this just learning the term for the first time. So why don't we just start here? What is a special real estate commissioner?
So a special real estate commissioner is someone who is appointed by the court to handle a typically more complex transaction that involves people it could be a family court appointment for a family who's divorcing and need to sell the real estate asset. Perhaps there's conflict, and they really need somebody who's going to be objective and fair and manage that transaction. It could be something that's more related to a partition action, where you have you have two or more parties who have equitable interest in a property, and there is some conflict involved in what we're going to do with that property. Perhaps one party wants to sell, another party doesn't, and so the court becomes involved, and a special real estate commissioner is appointed to help handle and manage the sale of that property if that's what's decided to occur. And then thirdly, I do get involved in a lot of probate cases where there's disposition of the property that hasn't necessarily been spelled out in a will or any other instruction. And so upon needing to sell that property, there needs to be somebody who kind of understands the process and can walk the family, who's often very overwhelmed in a situation like that, through the various stages of a probate sale.
So essentially, it's the court needing to get involved in the sale of real estate, but they can't go do it on their own. You're kind of an arm of the court in that regard. Is that right?
Yes.
Yeah. So break down for us then, what is required to become a special commissioner? I can't imagine you just go fill out a form as a real estate agent and we're good to go, right? What do you have? What has to happen for you to act in that capacity?
The court does have some requirements to become a special real estate commissioner. You have to have a minimum of 3 years of licensure with the Arizona Department of Real Estate. You need to do a minimum of 5 transactions per year. You need to carry errors and omissions insurance. You have to go through a mandatory orientation and maintain continuing education credits as directed by the court. And you obviously have to be willing to accept appointments and then follow court orders.
So you've laid out the 3 main areas or types of cases that a special commissioner might be appointed in. Let's start first with family law. What's the process for you to be appointed in family law? Obviously, the petition has been filed. The parties presumably, need to get a house sold, a marital home sold. What next? I mean, how do you become involved in that?
So there are a number of ways that a special real estate commissioner can be appointed. The first and easiest way would be if the parties are in agreement about a particular individual to take on that role. The most recent case that I had, that was exactly how it happened. I was so a friend of a friend referred someone to me who was getting divorced, and she wanted to use me as the special real estate commissioner. The husband was a little iffy on it, as is expected in many cases. I was able to meet with him. He got a feel from me that I was going to be fair and unbiased. And so both parties agreed that I could be appointed as the special real estate commissioner. And that's exactly what the court decided to do. In the event that, and does happen sometimes, in the event that the parties cannot come to agreement on a particular individual to fulfill that role, then there's a process that the court enacts in which each party comes up with 3 names of potential candidates to fulfill that role. They exchange those names. Each party strikes out 2 of the names. So you end up with one name per party. That is then submitted to the court. The judge has no idea who recommended which name, and the judge can then decide upon appointing one of those names. If in the event that, we just can't get through that process in a timely manner because of the degree of conflict, then the court can, on its own motion, just go ahead and appoint a special commissioner.
So what does that process look like? Just kind of starting at the beginning, talking about, assuming the parties can all get on board and voluntarily do it. What does that process look like for you as the commissioner? Is this kind of an interview process, them to feel out what you're going to do, your ideas, how this is going to happen? What can be done to kind of gain the trust of all the parties to the transaction?
Yeah, I mean, I do meet with both parties, assuming that they're both interested in working with me. I will meet with both parties, and as you mentioned, it really is about building trust with each party. And assuring them that I am really about the transaction and not about taking sides, because obviously that's the main concern for most people. They particularly if it's a contentious situation, they are concerned that they will be treated fairly, and that the outcome will be fair to each party.
Now, how do still talking about the situation where the parties can voluntarily agree, how is somebody like yourself usually referred as a possibility? Is it usually, well, one side happens to know you and you're a special real estate commissioner, so obviously that could be one way. Is there, a pool of commissioners that they can look at and consider as they're going? Because I would imagine, especially in the family law context, right? There's a sense that if the other side suggests it, it can't be good, right? So you already have to overcome that. What does that look like? Is that usually what you're having to overcome, or are they pulling your name kind of in a more neutral way?
There is actually a list of special real estate commissioners that I believe is with the Maricopa County Superior Court. And so people can just pull from that list. Now, do they know anybody on that list in particular? Maybe not. They may be going by the sound of the name that rings true for them. I'm not sure how people make that determination, but especially if each party is having to come up with 3 names, then they may just access that list and pull 3 names that sound reasonable to them. And as I said, eventually they come up with two individual names. Judge chooses one of those without knowing who recommended or suggested that name.
In the family law context, what is I know you haven't been taking probably metrics on this to know this to any point of certainty, but just your sense of having done it quite a bit. Are in the family law context, are the parties usually able to come to some sort of agreement, or is it usually pushed to the court to make a determination?
In my experience and in my practice, usually the parties have come to agreement, or as I described in the most recent case, one of them has made a strong suggestion and then has asked me to speak with the opposing party to see if we can get on some common ground. Part of the reason for that, I think, is because I am pretty well known as a special real estate commissioner. I do get referrals from attorneys' offices. And so I think because I'm a fairly known entity, oftentimes those referrals will come to me where there already is some measure of agreement.
So you mentioned attorneys, and I'm sure they're good referral sources for you. But what role do they play in this process? You mentioned the one that you recently appointed, the wife knew you, and then you were able to have a direct communication with the husband, and they ended up both on board. But what happens if they're represented by counsel, and, does that, affect your ability to be appointed? Does it assist with your ability to be appointed?
Yeah, and so in that case, both parties were represented by counsel, and so as soon as we had agreement, I contacted both attorneys and said, "This is who I am." I didn't know them; they didn't know me, so I introduced myself to them, let them know what my background and experience was, and we just kept those lines of communication open. It always works best when we're working as a team.
Do you find that if it gets to the point that the court has to appoint you in a family law type case, that it's harder to, if the court has to appoint you, that means the parties probably couldn't agree on it and whatever else. Do you have a sense once the court appoints you that it's harder to work through or gain the trust you were hoping to get on the front end? Does it always remain adversarial, or does everybody kind of let the judge's decision be what it is, and are they able to basically move on with that and let you do what you need to do?
In some ways it's easier if the court is appointing, because I don't have a previous relationship with either party. And so I don't have to overcome one party's concern that I've already taken aside. So I really do come in as a neutral party. Now, that being said, if the court is having to appoint because the two parties just cannot get on board, then I'm pretty much prepared for a more contentious process as we go forward.
Because if they can't agree on that, what can they agree on, right?
Exactly.
So what happens when you have a disagreement amongst the parties? You know, that maybe you have a good offer and um, one side wants to accept it and the other side is being obstinate and refuses, or maybe even refuses to really communicate with you. Um, is your role in that scenario?
Well, I think my background really helps because before we even have an offer, I have already gotten a pretty good sense of how I need to deal with each of the parties, and it may be very different dealing with one versus dealing with the other. And as long as I can convey an attitude of fairness, I can usually figure out how to deal with each parties to get us where we need to go. We have a very singular goal in mind, and I stay very, very goal focused with both parties. Now, if we're having a real issue with one of the parties, then, fortunately, we can then get the court involved to help us apply whatever sanctions need to be applied if somebody is just behaving badly.
So, jumping from the family law context, and we'll probably jump in and out of these different areas, but you mentioned other areas of the law where you are and can be appointed as a special real estate commissioner. Sean and I aren't family law attorneys, so we don't see the family law context all that often. But in the real estate context, we see partition actions quite a bit. Pretty common real estate type of litigation, and real estate special commissioners are obviously involved in that process. So take us through your appointment in a partition action, and to the extent that differs at all from the family law context.
So, in a partition action, the person who's filing the complaint, the plaintiff, is at least in my experience, is usually the one who wants to sell the property, and is being opposed by another party, a sibling, or another family member who has other mean or desires in terms of how to manage that. And so it's, in my experience, it's typically the person who wants to sell who is the plaintiff. And in that case, when they file the complaint, they are typically asking for a specific real estate commissioner. And then it's up to the court to decide whether that person will be appointed or not. Again, oftentimes those special real estate commissioners are being referred to by the attorney handling that partition action. So that's where my name would come up. And the court, by the time I get it, the court has already decided.
So by the time
it's a little different.
Go ahead, Sean.
So it is a little different process than the family court, in the sense that the family court, you might file the petition, and you're really not thinking about the marital community or the sale, and you're not really asking for it initially until there comes a time in that case where it needs to be sold and assets need to be liquidated, versus partition action. I mean, from the get-go, right? This complaint is being filed. Are you ever consulted on the front end by, say, the plaintiff's attorney to say, okay, how much do you think this is worth? What would the process look like? How quickly do you think it will sell? I mean, do you ever consult before the complaint is even filed?
Yes, absolutely.
Yeah. So I guess a lot of that just goes into providing some due diligence on the plaintiff side to decide whether what is this going to look like? How much in fees do we want to put in this thing? Is there an exit strategy out of that? Very interesting. So now break down for us, just because we're comparing each of them. So the third area you see a lot of this is in the probate context.
Mm-hmm.
Walk us through how you kind of initially get involved there in probate.
So almost always I'm actually brought in by the probate attorney. So the probate attorney has been dealing with the whoever the family members are who are involved in that. And they have recommended me as a special real estate commissioner to handle the sale of the property. And I work very, very closely with the attorney in terms of making sure that things go smoothly in what can be a very complex real estate transaction. I have been, and with partition actions as well as probates, there are times where the actual, the interested party may contact me first. So, a sibling wants to sell a property, and they may contact me first and say, hey, can you tell me what that property is worth? And then I may get involved that way and then be in contact with the attorney. So it can happen in any number of ways.
Factually break down for me in a probate context when you actually get when there's a need to actually be appointed by the court. Because in a probate, they're either going to appoint a personal representative who has the authority to act on behalf of the estate, and that personal representative could go hire an agent to sell the property. It doesn't necessarily have to be a special commissioner. But what kind of circumstances arise that in a probate context tend to require the appointment of a special real estate commissioner?
That it's an interesting question, because I have the only time that the times that I've been brought in on a probate was when the attorney actually contacted me and said that, hey, we're going to be putting this home up for sale. We would like you to be involved in the sale of the property. And at that point, the court has then appointed me as the special commissioner.
I see. So what kind of dynamic? I would imagine there's got to be some similarities in the probate context with the family law context. Obviously, in probate, we're talking about somebody who's been deceased, but you're dealing with family members, right? You're dealing with family members of the deceased usually, that, and especially in a real estate context, maybe have memories tied and associated with that real estate, have some serious thoughts about what ought to or not ought to happen with the prospective real estate. And I would imagine there's a good amount of emotions that are tied up in it with regard to that might be similar in family law. Do you see that a lot in probate?
Yeah, I do. And fortunately, by the time, as you said, by the time I become involved, there is a personal representative who has already been appointed. And so I'm working very closely with that personal representative. Now, am I also consulting with other family members? Yes. The structure that the court brings to that process actually helps a great deal. And so we can work through issues that come up between family members, using the court system in such a way to make things move along and kind of get around some barriers that present themselves.
Now, one area I as we're kind of talking through this, I'm now thinking about examples that we've either litigated over, but one area where I've seen a special real estate commissioner get appointed that was related to probate, but also related to a partition, is where in an estate plan, somebody instead of the estate selling the property, the will has said the following three people or whatever are to get the property, right? So the estate's going to just convey by deed to three siblings or something. Now we've got three siblings on title of the property. The estate removes themselves. But not all these siblings want to continue owning the property, right? And now we've got the potential of needing you in a partition action. Have you run into that scenario?
I have run into that scenario. And again, you just take it step by step. I like to think about it as chapters in a book. And once we get through one chapter, it's ready to open up the next chapter.
So what are the kind of things that you have to, market to the family, or to those that are hiring you, the lawyers? You have to show them that you understand the process, but do you have to kind of show a plan for what you're going to do with the property, how you're going to maximize its value, so on and so forth?
Yeah, absolutely. So I think one of the most valuable things that I would hope most special real estate commissioners bring to the process is a very strong, very solid network of resources that helps streamline what could potentially be a very complex real estate transaction. And so things like strong relationships with a title company so that the title search can unfold. We can determine if there's mortgage debt on the property and if there are any liens, encumbrances, or encroachments on the property that need to be dealt with prior to a sale. Having a good bench strength in terms of appraisers. My job is to value the property, but there are properties out there that are very complicated, and I know my parameters, and if I need some assistance, I have to have that expertise in my back pocket and know when to contact them and bring them in for that type of assistance. Having a strong network of investors, I think, is also very important when you're doing probate work, in that there are times where the best course of action for the sale of a property is going to be to an investor. So knowing that there are people you can call on who are going to deal fairly and quickly with a situation is important. Things like contractors and repair people and stagers and movers and junk haulers, those are all really important to have easy access to, because these are all issues that are going to come up in various probate actions, probate sales.
You mentioned junk haulers. One of the things that I know that happens in probate is, when people die, they generally haven't cleaned their house out, right? So it has all their personal effects. Some people have more personal effects than others. What is your involvement in that process? I mean, you walk into a house and you have all this furniture and different things that you have to deal with. How do you get involved in that?
Yeah, we do. And I mean, that's one of the things that really drew me into this type of work is that, at heart, I started out my career as a social worker, and there is a strong social work element when you're dealing with these types of situations. You're dealing with grief. You're dealing with personal property that people have attachments to. Aside from all of the other tasks involved in terms of valuing the property, preparing it for sale, marketing, negotiating. Aside from all of that, there really is a strong social work element, and we get involved, and that's why having those strong relationships with those resources is just it's crucial. It makes the difference between a closing that's going to be really ugly and a closing that's going to be pretty seamless.
Well, it's something that I think people take for granted. This is kind of answering an earlier question I was thinking to ask, which was how often does your job become doing more than kind of the initial mandate, which is, the mandate from the court, sell the property, right? But we know to get a deal closed sometimes requires a whole heck of a lot than just sell the property. If you're dealing with a probate context where somebody's been hoarding in a house for 40 years, let's say, there is no such thing as just getting the deal closed. There's suddenly you're like a junk expert, or you're finding investors and all these other kind of things, really being almost kind of a Swiss Army knife to the transaction. I'm sure that's kind of what you feel like going into all of these and what makes you good at doing it.
Yeah. And I'm very fortunate to have a very strong team, not only of outside resources, but, I employ several agents and we work as a team, and everybody kind of understands the context in which these things happen and what's necessary to get the job done.
Do you find that being a special real estate commissioner, just compared to your just the normal role of being a real estate agent, is more complex, and in that by their very nature, you're usually dealing with problem properties. And I don't necessarily mean that the property itself is a problem, but there's some sort of dispute, there's some sort of issue. That's why it's in court, right? There's some sort of problem that has to be solved. And by their very nature, I don't even know if you've ever run into a garden varieties transaction that as a special real estate commissioner, they're probably all unique and complex.
They are all unique and complex. Some are less complex than others. I mean, I think the first one I ever dealt with was, there was one personal representative. There were no additional family members, at least that were known at the time. It was complicated, but it wasn't as complicated as some of the cases that I've worked on. I've had some where the property was in such incredibly bad shape, and had so much junk. I call it junk. I'm sure somebody else would call it treasure. That it really required us finding a very unique buyer for that property. And we could do that knowing not only what the condition of the property was, but also what the market conditions for that location was. And so that's how we were able to market that particular property that would have been considered a problem in the parlance.
And I know in the probate scenario, to Andy's point, there's a lot of emotions, a lot of opinions, positions. And so there are times where certain beneficiaries can be, more difficult than others. And one of the big disputes is the sales price. Somebody thinks that the house is worth a lot more than what, it can actually be marketed and sold for. Are you ever required to come in and testify and give, and explain what you did, how you marketed it, what, how you secured an offer, et cetera? What does that look like?
Absolutely. I have testified any number of times, and I come loaded with information. I do a very solid comparative market analysis at the very beginning. Like I said earlier, if it's a unique property, let's say it's a custom home, it's very difficult for me to pull comps for that particular property. I will hire an appraiser. I want the best information that we can possibly get for the best outcome for that family. So I come loaded with valuation information, what we've been doing to market the property. I feel obligated to justify, if we are going with an investor, I feel obligated to justify why that's the better course of action, rather than just marketing it as a typical property. And then I'm also providing information about the types of offers that we've been getting, how many days on market it's been listed, how many showings we're getting. All of this information, all of this data is presented to the court. So it's presented in report form, and if I am called to testify, then I will do that as well. It's very apparent, very obvious that this whole process is being oversawn, and with the necessity of court approval. So we make sure that we provide everything that the court needs to feel comfortable with that.
So break down for us from the time that you are officially appointed by the court. Okay, so your name has been put on a court order. You are the special real estate commissioner with all powers and authorities vested by that court. You then have some ongoing duties and obligations to the court going forward from there, from that point to the point they close the case. Kind of walk us through what some of those duties and obligations look like. You mentioned that might involve you testifying. Obviously, it might change from case to case, but what does kind of that timeline look like in a typical case?
Sure. So the first thing we do, obviously I'm meeting with all interested parties, trying to get them comfortable with who I am. In terms of the meat of the work, the first thing we're doing is we're running a title search. Hooking up with the title company, getting a title search done, making sure that we're not going to run into any problems prior to closing, or things that we need to disclose to a potential buyer. Second thing we do is we are evaluating the market value of the property, running comps. If we need to pull in appraisers, we'll do that. But we're getting a pretty good sense of what the fair market value of the property is. We're determining whether, based on condition of the property and market conditions for that location, we're determining whether we're going to very likely go investor route or we're going to put it on MLS. We are determining what we need to be doing to market the property in terms of enhancing its value. So do we need to get repairs made? Do we need to pull contractors in? Do we need to, slap on a coat of paint? What do we need to do to maximize the value of the property? I had a recent one where I was walking the property and I noticed there was this big crack in the stem wall. That could be a huge problem, and we don't want to run into the problem after we have an offer on it. So I pulled in a home inspector. I had them take a look at it and determine whether we needed to get an engineer in there to look at the foundation. Turned out it was nothing serious. So again, those resources they're just crucial to being able to have the flow of the process go pretty seamlessly. We're looking at the contents of the property. Do we need to get an estate sale company in there? What do we need to do to make sure that the property can convey in the way that the contract requires it to convey, with no debris left, all of those things. We develop a due diligence package to ensure that we can get the highest net for the property. And then we create a marketing plan. How are we going to get this home sold for the most possible value in the least amount of time? Once we get the offers in, we're negotiating, again, for the best possible outcome. And throughout the process, we're managing any court matters that come up, any requirements of the court for reporting, for testifying, as those arise, because it's just not the same process for every case.
Now, how much leeway, authority, and or discretion does the court provide to you, the real estate professional? Does the court have to approve every step of the along the way, the price it's sold at, the party that it's sold to, so on and so forth? What is kind of the interplay between you and the court as that process kind of reaches conclusion?
So typically, I'm afforded quite a bit of leeway up until the point that we have an offer in hand and we're ready to accept an offer. And at that point, that's when I typically get called in to provide some data to the court as to, okay, what have we done so far to get here? What does the marketing plan look like? What is the price based on? Show us the comps that you've used. And if there's a need to have a highest and best bidding process through a court hearing, that's when that will be determined as well.
In that hearing, can you present the offer that you have, right? And then can third parties show up and bid?
Yes.
Does that ever happen?
It has not happened in my experience, but I have heard that it has happened. I mean, they open it up to any family members or any other party that might want to make a better offer. And we have sat in those hearings where nobody showed.
For the third parties that might bid, does the court require them put up some sort of good faith deposits?
Yes.
Okay. What does that look like?
Like I said, I've never had it happen, okay. So I can't answer the question.
Some random person can't just come in and bid twice what it is and then not follow through.
Exactly.
I wonder now, where would is that final hearing published somewhere? Where might third parties learn about that?
So throughout the probate process, there are requirements that the court has, and you probably know this better than I do, for publications to be made in various newspapers and other resources. Sure. About the property. They're looking for other family members who may not be known to the personal representative or to the court, and then they could be advertising that this hearing is occurring, so that people can show up and give their highest and best.
Now, Sharyn, this sounds like a lot of work. It sounds like a lot more work than just putting my property on the MLS and hoping to get an offer. So talk to us about how a special real estate commissioner is compensated.
So, as you know, we have to be very careful about discussing compensation in the real estate world. And so, every agent that considers themselves a special real estate commissioner, they set their fee based on their standard of practice, and then the court can weigh in terms of reasonable and customary based on the type of transaction and the locale.
Now, are you paid up front by the parties?
No. Paid as part of the closing.
When do you get paid?
As part of the closing, the close of escrow.
Okay, so similar to a standard real estate transaction, you get paid from close of escrow.
Yes.
Okay.
Now, if I am putting out an exorbitant amount of money or any at all, I can request from the court that a payment be made from the estate. I have not had to do that.
Yeah. What do you do, or how do you handle the situation where, just think about the most adversarial process you can think of, where the people, one party won't agree to anything and everything has to go to the court for approval. I mean, just aside from your time, I know that the attorney's fees on something like that are usually extensive, and sometimes the court might penalize a party. How does the court typically deal with something like that? In because this is more of your time. The thing that everybody thought was going to be easy took months and months longer than it was supposed to do. What is there any recourse in that, or is it it just takes as long as it takes?
Yeah, I mean, I can give you an example. I had a family court appointment some years ago where the party that maintained control of the premises really didn't want to sell it. And so, we had this agreement, we had a price. She just would not allow showings to happen. And she kept the home in such disrepair that even if we could show it, we weren't going to go anywhere. And it was, it was a very well thought out plan on her part. And so we were able to get a hearing with the judge and just explain that this person was creating a barrier to sale, and just not allowing things to go forward. And they did sanction her, and they threatened her with removal from the premises. And that sort of shaped her up. So that's the example I can give you in terms of probably the worst situation that I've run into. I'm sure there are worse ones out there. Fortunately, I don't need to speak to that.
Well, we know it's a special job. It's a difficult job, and one we're glad to know somebody that can do it when we have those kind of cases. Sharyn, we really appreciate you taking the time to discuss this with us. Tell our listeners how they can find and connect with you.
It's been a joy to be here. So my brokerage is Copper Summit Real Estate. We have a website, coppersummitrealestate.com. We can be found at the website. You can contact us by phone, 480-589-2347, via email, Sharyn with a Y, Sharyn at coppersummitrealestate.com. And we communicate the way people want to be communicated with. So whatever is anyone's preferred method, that's what we do to accommodate.
Awesome. Well, Sharyn, we thank you so much for being with us. Let's do it again soon sometime.
It's my pleasure. Thanks so much. I appreciate it.
All right. You have a good one. With that, everybody, that is our show. Make sure to join us for the collective this afternoon, and we'll see you next week.
Have a good day, everyone.